Okay, so welcome to the afternoon. I hope you had delicious lunches. And I'm going to have the opportunity now to have a conversation with Rajesh, who, if you don't know, has been for maybe 2 or 3 weeks out of his last position, which was General Counsel of the NSA, the agency that we've been hearing so much about. Before that, even though he looks very young, he did do a lot of things, and I thought I would mention to this. Just prior to joining the NSA, he worked at the White House, where, among other things, he helped organize the presentation of the President's Daily Brief, a job that many other interesting folks have had before you and something you guys can Google. He also served as counsel on the 9/11 Commission report. So somebody who's been in the field of the threat environment, the security environment, the cyber environment, and now the highly politicized NSA environment. And so is well acquainted to these kinds of conversations, both in public and in private. He clerked for the Ninth Circuit Court, as have others in our audience, and now he's currently a partner at Meyer Brown. And what I always say about government officials is, how long before you're going to want to go back? But that's not my first question. So I want to I want to get to the NSA, but I want to ask you a couple questions about what happened when you first went there. In other words, you were picked to be the general counsel there, coming from the White House. You came 6 months before the Snowden...
About a year.
About a year before the Snowden revelations. And I'd like to talk a little bit about that period of time before you actually got into that conversation. And when you got to the NSA, did anything surprise you? I'm sure there were a lot of programs that you were read into once you got there that you hadn't heard about before. Given the task of having to be the lawyer, and I don't expect you to tell us anything that you can't tell us, but just in terms of, but feel free, no. But just in terms of the portfolio you inherited, how would you describe it? And how would you describe your response to it?
Well, thanks for having me. It's so great to be here over lunch, because before lunch, everyone's thinking about lunch, and after lunch, you'll all be asleep. So I think this is like prime time to have your attention.
They're not asleep.
So it was a real thrill to go to NSA. I did not have a deep background in surveillance law, but I did have a background in the intelligence community, having worked on the 9/11 Commission, and I had worked on some Patriot Act issues while at the Justice Department. And having served in the White House, reviewing all the paper that goes to the president, I think I had a pretty good sense of what the intelligence community produces and how valuable it is to our policymakers. But like anybody, I was pretty nervous when I took this job. And so I asked my mentors and friends, should I be nervous? Should I take this job? And I like to tell the story because it's actually illustrative of a broader point. So I asked lots of people, and I actually got 2 pieces of advice that were completely opposite of one another, and both of which turned out to be completely wrong, but not for the reason you'll think when I say them. So one group of people told me, don't worry, take the job. Everything they do is secret, so if you mess up, nobody will ever know. The second group of people told me, you should be really worried because everything they do is secret, and you're the lawyer, and once you say something is fine, it's going to go ahead and happen, and no one will ever know, but you'll be the person responsible for allowing some activity to happen. Now, those pieces of advice were incorrect and actually quite misguided, not because, of course, we'd have leaks in the near future and more people will be thinking about NSA and thinking about what we do and reading about what they do, but because I was surprised at how many people are involved in the intelligence activities that we conducted at NSA. And I won't go into detail now, or I'm happy to if you'd like to, but serving as a GC at NSA actually was like serving as a general counsel for a very highly regulated enterprise, and I did not expect that at all. There are many people looking within government, within all 3 branches of government, looking over the shoulder of what NSA does, and that was not something I had anticipated.
So by that, you mean that whatever policies there are that are legally under scrutiny for whatever reasons, you weren't the only person to weigh in. There were other equities that had to weigh in. So other departments in the government, state, treasury, et cetera. Do you think that was new to NSA? Do you think that's a post-9/11 thing? Do you think it's a post-Obama thing? I mean, there is this push for the interagency within the intelligence world in the post-9/11 age, where you've seen more and more departments claim that they have an intelligence portfolio. Some of them surprising, some of them like FBI not surprising. So do you think that's changed and where?
I think it's evolved over time. Some of it's inherent in what NSA does. So for those of you who aren't that familiar, it's part of the Pentagon, part of DoD. So you have a whole cabinet department that oversees what NSA does. We're also part of the intelligence community. So NSA reports or has oversight from the Director of National Intelligence and all the structure that comes with the DNI structure. The Justice Department has a significant oversight role of NSA. So within the executive branch alone, you have kind of three major cabinet departments that have significant oversight of the agency. And I'd say post 9/11, there's probably been more attention from the White House and the National Security Council than before. So you have that layer on top of it, which can mean the NSC staff. It could also mean the President's Intelligence Advisory Board or the President's Intelligence Oversight Board, two bodies to which I, for example, sign out when I was the GC quarterly reports on all the mistakes and so forth that were made at NSA. I'd say post 9/11, there's also been increased scrutiny from Congress, and that's something we've seen evolve. In the immediate aftermath of 9/11, some of the surveillance programs that we now are reading about were strictly conducted within the executive branch, by and large. But over time, and I think for good purpose, they've received much more congressional oversight and validation, and as well as the Foreign Intelligence Surveillance Court, which has oversight of all FISA matters. And so some of it has been there for some time. The FISA court, for example, was established in 1978, so that's been around for decades. Some of the executive branch structure has evolved, and I think the congressional oversight is moving in a positive direction, at least post 9/11.
But when the buck stops with NSA policy, where does it stop? Are you saying it stops with the White House, it stops with the president? If there's a policy that's going to be put in place, is it the AG with the DNI, or where exactly is the top of this pyramid?
You know, it depends on what the issue is. So at some level, all policy in the executive branch is controlled by the president, but it's far more nuanced than that. And certain matters are within NSA, certain matters are within the intelligence community. I think what I discovered and was surprising to me is how much is external within the executive branch and even within all three branches of government than I would have thought. I would have thought more things are handled just within NSA, but the amount of lawyering that happens across the executive branch and throughout is astonishing, actually, and comforting. You should all feel I felt comforted when I saw that, because it meant that everybody wasn't relying just on my judgment. I'm just one person. And I think the public should feel comforted that we have lots of really smart, thoughtful people thinking through these issues.
So you're mentioning the law and lawyers, and Congress. So let's talk a little bit about the laws that govern NSA, which have, as you referred to in a kind of nice way, existed outside a legal framework at first, and then parts of them became codified into law, what we now call the FISA Amendments Act, and in other laws. So do you see this law as evolving further? And if you do, what do you think? Jane Lute was just here talking about what laws need to be had for regulatory purposes. I'm curious on your take on the law and where it stands, and if it's enough or if it's too much. And just, now that you're not there anymore, where you actually...
Now that I have free reign.
Yeah, now that you have free reign to think about what would be the ideal law that could balance some of the concerns.
Well, I think we are in a bad place if the law is not constantly evolving. So to suggest that it ever does not need improvement would be folly, and I think it should be constantly moving. Now, one thing I think became perfectly clear to me in the job at NSA is it doesn't move quickly enough. And the idea of going to Congress to get a change in the law is so daunting that it is often just a complete showstopper right there. If you think you have to go to Congress to have the law changed, it's almost as good as saying that's not going to happen anytime soon, so we either have to not do that or figure out a different way to do that. And that, I think, is bad on many, many levels. And it's just one byproduct. This is just one area. It's true across the board. We hear about the dysfunction of Congress. But given the pace of technology and given the pace of the evolving threat, at least in the national security space, if we don't have a legislative process that can keep pace, then we're going to see situations where we have a growing gap between what the law was designed to do and how it's being implemented, and that is not healthy in a democracy at all.
Let's turn to the issue of trust. that both Michael Morrell and Richard Clark mentioned this morning. So one of the things that came up, and I think some of the people in the audience mentioned it, was that one thing that did happen with the terrorist surveillance program, with Stellar Wind, with the Snowden revelations, was a sense of distrust for the NSA, which, inherent in any kind of surveillance authority, there's going to be some kind of distrust, but took a real leap forward. Yeah. And so there is a challenge to get people to trust the NSA or not. And I guess my question to you is, how much do you think citizens actually have to trust the NSA? Isn't it maybe a good thing not to trust the NSA so that you do have some kind of give and take? And just how do you think we should think about this?
So a few things. One, I think trust, in my mind, is kind of a misplaced word in this context, because I agree with you that I think as a public, we should have skepticism towards our government. We should, not just for national security matters, but in general. That's what this country was founded on, and I think it's healthy. And it's just as healthy in the national security space as anywhere else. But I think public legitimacy is really important for any institution in a democracy, and even if that's for an institution as secretive historically as the NSA. And having that public legitimacy about what is the mission for a place like NSA, what is NSA supposed to be doing? Are we comfortable with the broad contours of the legal framework within which it operates? Those are questions that I think properly should be aired publicly and discussed publicly. And, would I ask all of you to trust a big super secret spy agency? I don't know if trust is the right word. It just doesn't fit in some sense. But understand what it does, feel like it's a legitimate organization in a democracy like ours, feel like you have some say through the democratic process. I think that's all really important.
So if you had one recommendation you could make, not to establishing trust, but to maybe inserting into the law or the decision-making process something that would satisfy some of the, for lack of a better word, civil liberties advocates, is there any 1, 2, or 3 things that you can think of that could be put inside the law to reform the conversation, to reform the process, or do you really think, given national security concerns, that's really just not a road that we're going to go down?
I don't know if I call it a legal issue, but I think we have to figure out a way to have a long-term, constructive, sustainable dialogue about national security issues and intelligence issues in particular. It's not just limited to the NSA. We see these conversations happening all the time, whether it's Guantanamo Bay, the drone program, obviously in the news a lot lately. And I don't think we figured out how to do that in a sustainable, constructive way. It's sort of these one-offs. The government, in response to the Snowden crisis, puts out a lot of material. But I'm not sure we've institutionalized a way to have that conversation. Now, there are pieces happening. The Director of National Intelligence issues now an annual transparency report about FISA. So this is one little piece of it. But every year now, a report will come out that talks about the number of orders that are issued pursuant to various provisions of FISA and the number of targets that are impacted by those orders. Now that, maybe it's not as granular as some might hope, but it gives one a sense. I think there's...
It's his fault.
There's some NSA joke I can insert right now, but I'll keep it to myself. Now that is a new way to silence a government official that I have not heard before.
No, that is... Okay, continue.
So this idea of...
If we start to hear alarms, we'll just stop for a few minutes and whatever.
Of fostering a way to have a public discussion is really important. And there's lots of ways to do it. This report is just one way to do it. The government is now committed to trying to release more opinions from the Foreign Intelligence Surveillance Court, for example. You have more officials like me, or at least in my former role, who are out there trying to speak more about the legal construct within which our intelligence apparatus operates. You have the Privacy and Civil Liberties Oversight Board, Judge Wald, I know he's here, part of whose mandate is to try to make some of these issues accessible to the public and explain them. And so there are I would say that is an institutional imperative, and in a democracy we should be pushing that, but I'm not sure it necessarily requires a change in the law.
So one of the things you and I have talked about, and one thing that was brought up this morning, was Edward Snowden. And I don't want to get into the Edward Snowden stuff. We can leave that unless you feel like there's something you want to say. But what I do want to ask is that being at the NSA for the year before Edward Snowden and then for these years afterwards, was there a change of culture? What did it change inside the NSA, and particularly, I think, in your office? And so what happened there?
I think the most immediate impact that was apparent, at least among the workforce, was it was very demoralizing. I was new to the agency. I only been there a year. And, GCs generally come from the outside and leave after a few years. I was there for 3 years, which is a typical tenure. But many, many folks at the NSA, that's their career. They come and they want to serve in the public sector. They want to help protect America, and this is their career. And I think there was a feeling of, there was this feeling of kind of betrayal of a fellow colleague. Yeah, we'd all feel that. In any workforce, if the person sitting to the left of you did something that wasn't what you were brought up to do, one would feel that. So there's this sense of betrayal. I think broader, there was a sense of demoralization, the sense of being pilloried in the public for what folks felt like was appropriate and legal activity. Now, reasonable people can have a very thoughtful dialogue about what NSA should be doing, how the law should be structured, but there isn't really, and I think we've seen this in the public revelations, there really shouldn't be too much of a debate in my mind about the legality of what NSA has been doing and whether it fit within the legal and policy framework that was relevant at the time. And you imagine yourself a line worker in any institution feeling like there is a public discussion about whether what you're doing is legal, moral, ethical, how could you do this? And in fact, many of these programs, or much of what happens in any intelligence apparatus, is compartmented. So imagine many people in a workforce of tens of thousands have no idea what other parts of the agencies are doing. So it was very startling for them at a very personal level. So that, in a very practical, personal way, that was some of the impact. I think some of the lessons that the government has drawn, it's not limited to NSA, but I think big picture, clearly this idea of including the public more in a conversation is necessary. And the broader the gap grows between what institutions of government are doing on our behalf and what people think they're doing, the more dangerous situation we're in a democracy. So that's part of it. I think there's also a sense that policymakers and the intelligence community need to be more tightly integrated. When there's some shock about what certain activity may be, how certain intelligence activities are carried out in a very granular way, when they're being done in response to questions that policymakers have asked, and you have that disconnect, that's a dangerous situation. And this is just a very oblique way of referring to spying on foreign leaders, for example. And I'd say the third major area where I think there's a sense that we need to evolve is in how we think about risk, particularly in terms of intelligence collection in the information age and the digital age. And we need to be thinking through risk not just in a very narrow sense of intelligence risk or operational risk, but economic risk and so forth. And so there have been changes made to address some of these issues, but I think those are some of the big meta issues that have come out of this.
Okay, well, you started with the public dialogue. So let's take a couple of questions, very quick questions, if anybody has any for you. Right here.
Hi. We talked a little bit before about the inherent conflict between collection and operations in cyberspace, and you had the unique position of working for somebody who's dual-hatted with Title 10 and Title 50 authority. I was wondering if you could offer your perspective on that issue. Or do you think it's a good idea for those authorities to reside under one hat, or perhaps moving forward, two different hats?
So the question is a reference to the director of NSA, most of you probably know, is also the commander of U.S. Cyber Command. And just so you all know, I was the GC for NSA, so I was the chief legal officer for the NSA. There is a staff judge advocate who is the chief lawyer for Cyber Command and advises now Admiral Rogers and General Alexander for Cyber Command issues, just like any other unified commander. This is actually a sub-unified command. But the bigger picture issue about different legal authorities, so first on the dual hatting, I think right now it's the appropriate setup. And I say that because as a practical matter, it would be too wrenching to have two separate organizations duplicating a lot of the same infrastructure that goes into doing intelligence work or military work in the space. Now, we should reassess that over time, as we should with all structures, but that particular structure came under intense scrutiny in the aftermath of the Snowden leaks, and President Obama reaffirmed that he thought this was the appropriate structure for the status quo for the moment. On the authorities question, this is a question that lawyers in the executive branch deal with all the time, whether it's Title 10, Title 50, the shorthand for sort of performing activities under military authorities or under intelligence authorities, or there are law enforcement authorities that the Bureau exercises, for example, that are not in the intelligence world. And one of the most difficult things of being a lawyer in the national security space that crosses military, intelligence, as well as law enforcement, is to figure out a way to accomplish the operational end that the client may have, even if that requires some thoughtful and partnership thinking with other agencies. So there's many times when we may do joint operations between agencies, and that may draw upon the legal authorities that are inherent in a law enforcement agency as well as an intelligence agency or a military enterprise and a intelligence enterprise. I think that's very healthy because, firstly, that brings more people to the table to do with an exercise, and it makes sure that our operational activity isn't constrained by the somewhat artificial delineations we have between what's military and what's intelligence and what's something else. And so good lawyers are working together to help figure out how to accomplish something, often crossing those lines.
Any other questions? Back here.
Hi, I'm Leah Goodwin, and I'm with Newsweek, just to warn you.
No worries.
I recently did an interview.
Literally saved by the bell.
I recently did an interview with the former head of GCHQ, and
Hang on. Let's wait till they're done. We have extra time in the schedule anyway between this and the next event. So something maybe next time I'll bring up with Fordham, like, could you tell us if you're going to... It's a nice room, though. It's a very nice room. You should say everything right now.
This reminds me of the first time I testified in the Hill, and they were having a vote, and I got broken up every 5 minutes, which was the best thing ever, because I never really had to actually testify. Every 5 minutes, the members were going to vote.
All right, let's try this again.
okay, I'm going to give it a shot. I think what he said, he said, I think we missed a trick in not telling the public more about what we were doing, and GCHQ follows different rules and often more liberal rules in England, according to him and according to most of the research. However, I think even if, from a legal perspective and from the privacy and public dialogue perspective, even if we were to say that all of our democratic values align with the US law in what is going on at the NSA, he said that frequently they use intelligence gathered through GCHQ that follows very different values and will often go places that we don't, out of respect for Americans, as a way to spy on Americans. So how do you feel about legal arbitrage in these partnerships with other countries?
Yeah, I'm glad you raised that, because I think generally there's a concern, you have officials like me who come out and give a sense of what the U.S. legal structure is, and of course a natural question is, well, fine, he's saying you don't do it, but do you go and ask GCHQ or pick your country to do the work that you can't do at NSA? So a couple of things. One, let me just talk about institutional relationships that the U.S. government has and then the legal framework within which that operates. So many of you probably have heard of the Five Eyes. That's a reference to the US, Canada, UK, Australia, and New Zealand. And these 5 countries, for legal and historical reasons, have had a closer relationship than others in the national security space. Mm-hmm. And so, yes, it's true that our intelligence agencies work closely with the intel agencies in those Five Eyes partners, more closely than with any others in the world. But that does not lead to the conclusion that one should fear, if it were true, that we would be skirting U.S. legal laws or conducting legal arbitrage. So it is a baseline rule that the U.S., as a legal matter, the U.S. government cannot ask a foreign government to conduct activity that it would be prohibited from conducting itself. That is just a baseline truism. So it does not happen, and if it happens, that would be a matter for investigation and so forth, like any other illegal activity. But we, of course, can't constrain what foreign governments do on their own. And I do think the issue that is inherent here about global norms of privacy is a real question. So going forward, apart from the spying issue in particular, but given that this is a conference on cyber and a lot of these issues are interrelated, I do think it is imperative that we move towards a greater global consensus on norms about privacy, because these issues can't stop at the borders of any particular country. And that's just as true in the civil space or in the data privacy space as it is in the national security space. If you sit around in this room alone, and you probably turn to the person to your left and your right, most people have, I bet you wouldn't agree on 50% of issues dealing with privacy and digital issues. Now imagine that multiplied across our country, and then of course between the US and Europe and globally. And until we can get towards a broader core normative sense of what we expect in terms of digital privacy, I think it's going to be difficult to move forward on privacy issues around the world.
One last question, Evan. Here.
Thank you very much. In your new role as a partner at a law firm, and one that was allegedly hacked or spied on in the past, how do you think about a lawyer's duty for confidentiality and cybersecurity at an international law firm?
Definitely. Well, I think this is a pressing issue for lawyers around the world, and the reference was to a New York Times article from a couple of years ago that made allegations that certain intelligence activity by a foreign intel service ended up collecting communications of a U.S. law firm. So I think there's a few things. There are bar rules and so forth that impose obligations on lawyers, and we should take, all of us should take those very seriously. We should take those seriously both because there are ethical obligation, but also there's very practical consequences. Contrary to public perception, there actually are a lot of rules in place about how attorney-client privileged information that may be obtained by the government has to be handled. So for NSA, we have certain things called minimization procedures. They're basically privacy rules approved by the Attorney General. And under these rules, there are actually sections that deal with how privileged information or potentially privileged information may or may not have to be sequestered, the uses it may or may not be able to be put to, when it has to be destroyed, and so forth. Now, very practically speaking, as a lawyer, part of the reason for stamping something with attorney-client privilege is, if you're in civil litigation, of course, you can make a claim and that helps you. It also alerts people that this is potentially privileged information. Don't underestimate how important it is to take one's duties seriously, not just because they're ethical duties, but they're very practical consequences. How would an analyst in a hypothetical intelligence institution know that something is privileged? It's quite difficult, actually, but if you're a lawyer and you stamp something with attorney-client privilege, at least you are kicking in the system that is supposed to work when that material is in play.
Mm-hmm. We're going to have you back because we need to ask you more questions. But we're going to not take a break. We're just going to reassemble ourselves and move on to the next panel. Thank you very much.
Thanks, Karen.